Hi, and welcome to the Financial Quarterback. My name is Richard Hand. I'm a certified financial planner with Valley Forge Wealth Management, located just above Phoenixville, Pennsylvania. And today we're going to talk about some of the legal implications of one's financial planning. And really the show that we have is meant to help educate the public in how to tie different areas together of one's financial well-being. So for example, making sure that your wills and things like that are done appropriately is very important to your overall financial plan. If they're not put together correctly, the best intentions can, go terribly wrong, which is unfortunate. Today we are here with Levi Wolf of Wolf Baldwin and Associates in Pottstown, and he's going to help me go through some of the technical aspects of the process when one passes away and what one should do prior to that to make sure that their wishes are carried out and things are done as correctly as possible. Levi, welcome.
Good morning.
So, a little bit about yourself.
Sure. My name is Levi Wolf, obviously. I've been practicing law for 17 years here in Pottstown. Joined my father's law firm. He has been practicing in Pottstown since 1973. We have 3 offices in Pottstown, Westchester, and Reading, and we have 7 attorneys. So we have a broad spectrum of practice. We do a lot of wills and powers of attorney, living wills, probate and estate administration. We do real estate law, we do contracts and civil litigation, we do a lot of workers' compensation, family law and divorce, and we have a municipal law practice where we represent local boroughs and townships. So it's a wide practice area, but I've been writing wills and powers of attorney for 17 years.
Okay, fantastic. Sounds like a nice breadth of knowledge that you folks have.
We like to be in a position where we can help our clients with most things that come in the door. So if people have problems, we've tried to be here to help them for many years, and we like to continue to do that into the future.
Terrific. All right, so Levi, how are the different ways that property can pass when somebody passes on? There's often a large misconception out there in the public as far as how this stuff actually works. So, right. What are the different ways that things pass?
Well, you can think of there's whole chapters in law school that you go through about title to property. But essentially, when we're talking about things that pass under a will or even without a will, it's usually things that have a deed or it's personal property. If you own your bicycle, you're not going to have a title to it necessarily. But your car, you have a title. Your deed to your house, you have title. It's the deed, right? So there are items that pass that are titled and things that pass that aren't titled.
Right.
The things that pass that are titled, like a deed to your house, they can pass a couple different ways. By operation of law, they can pass under the will, they can pass without a will, they can pass through a trust.
Okay.
There are a whole other segment of property, such as life insurance proceeds, that you sort of only have equitable title to. You don't actually own that property until it comes into your hands, as opposed to legal title. So you might own the insurance policy, but until the person dies, it doesn't fund.
Right.
But those things pass by operation of contract as opposed by operation of law. So things like your IRA. You own your IRA, but the beneficiary gets it by contract because you've designated a beneficiary. So those are generally the categories of things that pass, and the way they pass, like I said, are operation of law. So, for instance, a deed where you have a husband and wife that own the property. There's a tenancy that is created by that deed. Typically, when husband and wife own the property, we call it a tenancy by the entireties. A technical term, but it means that if the husband dies, the wife gets it, and if the wife dies, the husband gets it. It's automatic. It happens at the instant of the one spouse's death. It's a subset of joint tenancy by right or survivorship, which is the same thing but for people who aren't married to each other. So if you and I own property as joint tenants with right of survivorship, same thing. You die, I get it. I die, you get it. It doesn't have to be 2 people. It could be many different people, or it could be sets of people. So you could have husband and wife A, husband and wife B, and husband and wife C all own property by joint tenancy with each of their individual pieces, joint tenants with right of survivorship. The third way that you commonly see on deeds is tenancy in common, which means if you and I own property as tenants in common, you have a 50% share and I have a 50% share, but there's no action that happens on one of us when one of us dies. So if you pass away with your 50% share, your estate gets it, and I still own my 50% share.
Got it.
With contract, we talked about that. So contract would be a beneficiary designation typically. Items can be passed by trust, so I can create a legal fiction of a different owner of the property, where if I own this piece of paper or I own this pen and I want to give it to you in trust, I take that ownership that I have, my legal title, and I give it to the trustee. And the trustee then has the legal title to the property to be able to sell it or mortgage it or lease it, do whatever the trustee needs to do, but the benefit, the equitable title of that trust would go to the beneficiary.
Okay.
So trusts are very broad. Trust you can do almost anything imaginable with. You can hold on to the ability to control that property for a very long time after the trustee is gone. And you'll often see that in a little bit higher net worth estates where people want to make sure that children or grandchildren are taken care of. And then you can also tell the trustee what you do with the money. So I want it to be held only for education. I want it to be held only for grad school. You know, you can be very specific. In our practice, we make sure that pets are taken care of.
Really?
So it's not uncommon to do a pet trust where, obviously the pet can't own property, but the trustee can. So the trustee can hold on to money from the person's estate to make sure that a loved pet is taken care of.
That's nice. Didn't know you could do that.
You can do that.
Interesting. Often, Levi, I meet clients, and I'm sure lots of people out there do this, naming their children as secondary beneficiaries in a life insurance policy. So if one spouse predeceases them, then the children would get those proceeds if the second parent passed away. Is there a problem if a 12-year-old has $1 million life insurance policy proceeds that's going to come to them?
Right. Well, we were talking about legal title a second ago. 12-year-old can't take legal title to that money. So that's a problem. And the ways around that are either to set up a trust or to set up a guardianship or a uniform transfers to minors account where somebody else, either a custodian under the Uniform Transfers to Minors Act or a trustee, can take control of that property, or a guardian that may have been set up by the court. So there are various legal ways to get around the fact that the minor, him or herself, can't take custody of that property. When the life insurance goes to pay out to a beneficiary who is under 18, they're not going to do it.
That's right.
They're going to hold on to that money. If there is no guardianship, if there is no custodian, if there is no trustee set up, they're not going to write a check without having one of those people. They'll sit on that money until the child turns 18.
Now, for most kids being 18 years of age and maybe a freshman in college or something like that, receiving a check for $1 million could be problematic, maybe at best.
I think most of us who are parents would not want their children, even at age 18, to get that kind of money.
I would agree. Yeah, often for our clients, we utilize trusts for the secondary beneficiary, and that way if both parents are gone, that would be the real problem, and the children are in receipt of that money. Maybe they get some income off of it until a certain age, 35 or 40, when they get the corpus of the trust distributed to them. But hopefully at that point, the kids are a bit older and more mature and can handle that kind of money. Otherwise, they'd probably be the coolest kid on campus for about 3 months, and then that would be it. Until
they blow through all the money.
Exactly right. So
now that's one of the useful ways a trust can work. And also a uniform transfers to minors account where you can hold on to property to age 21 or even a little bit beyond in Pennsylvania that doesn't have all the trappings of a trust, but is sort of a trust light, so to speak. Okay. So two different types of trusts out there, really. There's the revocable type as well as the irrevocable type. You want to comment on each and some of the changes to the laws recently on the revocable type? those obviously can get very technical depending on what you want to do, but the general idea is whether you want the property to be in your estate or not in your estate when it comes time to pay the tax man when you die.
Right.
So with federal estate taxes, we have a lifetime exemption. It's relatively large right now. Who knows whether Congress is going to leave that alone. But the idea behind an irrevocable trust is you want to make a gift of this property to your beneficiaries, and by doing so you want to get it out of your estate,
Right.
so that it's not taxed in your estate when you die. With spouses, it's not such a big deal because there's an unlimited deduction between a husband and wife when you pass away. But when the second spouse dies, that's when you worry about how much credit do they have for federal tax purposes.
Sure.
Pennsylvania inheritance tax is not a huge problem, especially when you're talking about inheritance to children, because it's only 4.5%. Not nearly as big as the 36% and up of federal taxes that,
Right.
that somebody might have to deal with in a larger estate. So a revocable trust, when you can take it back, you need to be very careful about how you set those up, because the IRS might not consider it as a completed gift, and it may still be in your estate for tax purposes, even if you thought you don't have it anymore and you've given it to the trustee.
Gotcha.
So we get into items like living trusts and things like that, where people are putting money aside during their lifetime hoping to get it out of their estate. And I think we're going to talk about a little bit of that more later.
Sure, sure. Often in 23 years of practice, sadly, I've seen many older people that I've met with these living trusts that are sold as sort of a panacea for all their probate problems or perceived problems, and they usually come in a very nice gold-leafed, shiny 3-ring binder full of all kinds of interesting documents and things like that. And generally, these folks have paid quite a bit of money for these trusts to be set up, maybe $5,000 to $10,000 in some cases, which is a lot. And many times these people have smaller estates, only a couple $100,000, $300,000, $400,000. Have you seen that? And is that something that is maybe overdone in many cases?
I would agree with that assessment. Yeah, it's unfortunate. I've had over the years a number of people who've come into our office that have been sold these packages, and there are reasons why to do them, but they don't generally apply in Pennsylvania. The idea behind a living trust in general is to take your assets and shift them out of your own legal title into the title of the trustee.
Correct.
Where the idea is that upon your death you can avoid probate. Probate isn't necessarily something that needs to be avoided in Pennsylvania, and there's a lot of reasons why you want to go through the probate process in Pennsylvania.
Sure.
Living trusts are thought to help to avoid probate. They're thought to help to avoid taxes. They're thought to be more private, something that doesn't have to get filed with the court.
Right.
In general, it's hard to actually achieve those goals with a living trust in Pennsylvania. First of all, the living trust only works if all of your assets are actually transferred into the trust.
Right.
So as soon as you have your house that gets transferred into the trust, but your car isn't, you may still have to probate your estate even though you have a living trust. So it's very difficult in actual practice to make sure that this vehicle actually works, because without that follow-up of making sure that every asset you own actually goes into the trust, the whole thing blows up.
Yeah. Usually as sort of like the financial quarterback for people, that's what financial planners do. We'll make sure that if they do have one of these type of trusts, that assets actually do get transferred into the trust. Otherwise, to Levi's point, a lot of their assets will still have to go through the probate process, and they spend $5,000 on an empty trust, which is very sad. I think oftentimes seniors are taken advantage of by unscrupulous folks who might not even be real attorneys, who knows, but they do get that shiny book, which is very nice. So
I would much rather have them come into my office and spend the time with me to understand what they need to have done to make sure that their wishes are taken care of, and charge them a whole lot less money.
Exactly right. So it's all about knowledge and knowing how things work, and what are the best ways to affect the outcome that you desire. So, all right, so what happens in Pennsylvania or many other states if you pass away and you don't have a will?
Okay.
And what's that process about?
That's called the intestate process. So when somebody passes away with a will, we call them testate. When they pass away without a will, it's intestate.
Very clever.
Neat how that works. The Intestacy Law in Pennsylvania spells out how assets are distributed when a person doesn't have a will. People die without a will all the time. A common misconception is that all the property goes to the state at that point, and the Commonwealth of Pennsylvania takes everything, which is not true.
Escheatment, is that what it is?
Well, escheat is when somebody holds property for somebody else, but the other person never comes to get it.
Okay.
So the escheat law, after 7 years, if you hold property, you're supposed to give it to the Pennsylvania Treasury to hold until the person comes to claim it. With intestacy, the estate has assets, but you die, everything that doesn't pass by operation of law to your heirs or beneficiaries is going to sit in your estate until it goes somewhere.
Right.
Right. So the intestacy law spells out where it goes.
Right.
Now, with any kind of estate, whether you have a will or you don't have a will, there's certain things that need to be done. You need to pay the taxes. You need to pay the affairs of the decedent for burial expenses. You need to pay the final rent that might have been due. You need to pay the bills that the creditors still have. So assuming there's enough money in the estate to pay all those things, then all those things get paid off the top. Right. You pay professionals like accountants and attorneys. You pay for the cost of a headstone. Those things have priority. Once all those other debts have been paid, then the beneficiaries can take what's left.
Okay.
So the intestacy law spells out how those assets are divided depending on who's still around that's in a degree of relationship to the person who passed away. So we call the person who passed away the decedent. And if the decedent had a spouse, then the spouse takes a piece. If the decedent had a spouse and children, then it gets split. If there's no spouse and no children, then they look to parents, they look to brothers and sisters, they look out to cousins. You have to get pretty far out before the state would actually take anything that's left. So usually we find some kind of heir that may be entitled to something. But more often than not, this day and age, people have wills.
Gotcha. That's good. So when somebody puts a will together, why is that like a better option than not having a will? I mean, it seems to make a lot of sense, but yet, as you mentioned, a lot of people don't have wills. I met an attorney not long ago who didn't have a will, which I found ironic, but...
The intestacy law works for some people. If you like the way the distribution is set up by the intestacy law and the legislature has decided how your assets are going to be transferred, then that's fine. The only difficulty is that who's going to administer the estate. Right. So without a will, you didn't have the opportunity to nominate who your executor is going to be and who's going to be in charge of taking all this property in, making sure all the debts are paid, and then making sure the beneficiaries are paid. With intestacy, we call the person who administers the estate, funnily enough, an administrator rather than an executor. So there are people who are laid out in the law as having priority in terms of the administration of the estate, such as a spouse, for instance. And the spouse can go into court and say that my husband or my wife passed away without a will and I want to be the administrator of the estate, and then they can get the stamp of approval of the court to be able to administer the affairs of the estate. With a will, it's a lot easier because you've nominated the person that you want to take care of that information. You want the executor to be able to do it.
And that doesn't necessarily have to be your spouse.
Not at all.
Oftentimes we'll find that one spouse is really financially more educated or involved than the other spouse, and maybe doesn't want the non-financial spouse to handle several $1,000,000 estate. Maybe they want their brother to do it, or their sister, or one of their kids perhaps. That's often the case. Maybe the oldest child is nominated as executor. So to Levi's point, if you don't have a will, the court's going to pick out who the administrator will be, and maybe that is somebody that you wouldn't have otherwise chosen.
Right. Or you may set up a battle between 3 different children, for instance, about who's going to administer the estate.
That's a great point.
When if you had nominated somebody, you would eliminate that issue entirely.
Yeah, it makes it a lot easier for the people who are already dealing with grief to not have to battle each other for what they think dad or mom would have wanted.
Right.
Yeah, that's an important point.
And that theme flavors the whole discussion about wills. The best thing about doing the will, and one of the beauties of the way our legal system works, is a will is one of the few vehicles that you can count on the law to enforce what your wishes are after you're dead and you're not around anymore to enforce it yourself. So if you write a will, especially if you write a will that's written by a lawyer, has a very high degree of reliability where you can have peace of mind knowing that your wishes are going to get carried out. And the law is going to make sure that what you put in that will is what actually happens.
Good. That's a great point. So different ways to get a will. Obviously, you can go to see an attorney like yourself, which would be the recommended way, since there are so many variables out there that people don't really think about when drafting a will. So you can also go to Staples and buy a off the rack, if you will, and try to fill it out on your own, which I guess is better than nothing. However, obviously there's vast, differences between attorney prepared and kind of,
right,
off the rack.
Well, we're in Pennsylvania. I'm licensed to practice in Pennsylvania. I can tell you what Pennsylvania requires in terms of a will. I can't tell you what New Jersey requires. I can't tell you what Colorado requires. And it seems to me that when you buy those prepaid legal forms, you are getting a one-size-fits-all cookie-cutter product that may or may not actually meet your needs. More importantly, I think the sitting down with the lawyer is important, so you can have a conversation. You can talk to the lawyer about what your goals are, what you have, the different types of assets that may transfer in other ways completely outside the will, like we talked about before with joint tenants with right of survivorship. You have a deed that passes property by operation of law. That's not even going to go through the will anyway.
True.
So there are a lot of pitfalls and traps for the unwary that a lawyer can pick up on. For instance, the difference between a per stirpes distribution and a per capita distribution.
That's an important one.
It is. When you pass away having children, if they have children of their own, but that child of yours passes away and you want the shares of the property to go through to your grandchildren, or maybe you don't, maybe you want it to be split between just the other children and not pass through to the grandchildren. That's what we're talking about with a per stirpes or a per capita distribution. I would think that the will form is not going to tell you about those options. So those are the sorts of things that a lawyer can help out on. And in general, the will not only chooses the executor and chooses the distribution scheme that you want to make sure that children or grandchildren or whoever are taken care of. You can also identify individual pieces of property. So if you have a particular piece of jewelry or a particular asset that you want to go to one person or another, you can make sure that those are taken care of as well. We can certainly take care of charities. We can take care of friends and neighbors and anybody who might be entitled to get a piece of your estate.
But you have to write it down.
Have to write it down.
There you go. How about that? And then in addition to the will, a couple other things that people generally should have is a power of attorney and maybe like a living will or advanced health care directive. They're just other important documents that should be sort of like the trifecta of basic estate planning documents for everyone.
Absolutely. When people come into us to talk about doing a will, we will always talk about doing a general durable power of attorney, and we'll also always talk about doing a living will or an advanced health care directive. Remember that a will is only good after you've passed away. And there's a very good chance for most people that they can become incapacitated without dying.
True.
So in that case, somebody needs to be able to take care of their business and handle their affairs. And that person, if you don't want to have them have to go to court and declare you incompetent, you can nominate people as your agent, your power of attorney, and they can handle your affairs without having to go to court. It's a much cleaner, much cheaper, much simpler way of making sure that your affairs are taken care of if you're not able to do it yourself.
Got it.
With regard to a living will or an advanced health care directive, we can think of Terry Schiavo, Karen Quinlan, people who are in persistent vegetative states, who may be terminal or may be in a persistent vegetative state and will never realistically wake up. And we want to make sure that their wishes are taken care of, and if they don't want to be kept alive under such circumstances, then they need to write it out and tell the world that they don't want to be kept alive by artificial respiration or kidney dialysis or getting blood products or surgery when it's not necessary.
So without one of those documents, really, it's going to be rock, paper, scissors with your,
well, in general,
with your
the doctor's going to want to keep you alive,
sure,
unless there's some very good evidence that that's not what you wanted.
Yeah, it makes it difficult for everybody. It really does. So overall, I mean, these topics are very complex, and one's financial assets really have to be orchestrated with one's legal documents to make sure that all the things that you want to have accomplished, you know, while you're around when you pass away are done as optimally as possible. So with that, I mean, it's extremely wise to seek out proper counsel from competent financial planners and attorneys and accountants, trust officers, insurance agents. All these folks work together as a professional team and should in their different areas of specialty. And as a financial quarterback, what financial planners do is we kind of lay out the strategy and create the blueprint to, you know, get people where they want to go. And then we'll do a lot of the things ourselves, like the asset management part and perhaps, you know, some of the insurance things. Really the rest of it, most firms like mine have relationships with different law firms and CPA firms and things like that to send our clients to. And that way then when I send a client over to Levi's office, I know that what they need is going to get done, and it's going to be done correctly. And then everything I do on my end is going to integrate nicely with everything he did on his end. And the client's going to be better off. There'll be, you know, less cost. There'll be a lot less fighting amongst relatives, hopefully anyway, when that day does come. And it's just a much better way to do it. Taxes are a moving target, and as Levi mentioned earlier, who knows what Congress is going to do? Congress doesn't know what Congress is going to do. So we always have to kind of plan for the worst and hope for the best in that regard. And each year we have to usually change things up a bit. But overall, getting professional guidance is really key. And both myself and Levi are very happy to help clients in the area achieve their goals.
Thank you.